Welcome to the first of a series of 4 webinars organised by AUSVEG in partnership with Australian Industry Group. I'd like to welcome all attendees to the webinar. For those that don't know me, my name is Lucy Gregg and I commenced work as the National Public Affairs Manager for AUSVEG late last year. I've spent the last 5 years working for the Tasmanian Government as Senior Advisor, most recently to the Premier of Tasmania, Jeremy Rockcliffe, who himself is a vegetable grower. Prior to that, I've worked for over 20 years in primary industries across a range of executive roles from domestic sales, quality assurance, export sales, marketing and business development. Although a large percentage of my roles have been in the fruit industry, I've also worked across beef, sheep, mixed cropping and vegetables. Horticulture has always had a heavy reliance on workforce. It's the nature of the industry, and changes to workplace law can have substantial impacts on our sector. Late last year, there were significant reforms to the Fair Work Act with the passing of the Fair Work Legislation Amendment, Secure Jobs, Better Pay Act 2022. Since the passing of the Act, it has been difficult to source detailed information on how changes may affect the horticultural sector. Given the uncertainty around the changes, AUSVEG wanted to ensure that our growers had access to accurate information and timely advice. We also want to ensure that the industry is kept informed about what changes may be ahead in further industrial reforms planned for 2023. AUSVEG understands how important workplace relations are in the running of your business. Recently, we have made submissions reinforcing the importance of PALM and other visa schemes, including the introduction of a harvest visa. Through the NFF Horticultural Council, we've put ideas and feedback to the Tripartite Agricultural Working Group, formed as a result of the Jobs and Skills Summit that includes representatives from government, industry and unions. For those that don't know, AI Group is one of Australia's largest industry associations, which represents the interests of more than 60,000 Australian businesses. AI Group has a strong focus on industrial relations and they employ around 40 industrial relations lawyers across the country. Their commercial and small business focus and strong advocacy in workplace industrial relations makes them a perfect partner for AUSVEG. Given their strong advocacy platform in industrial relations, it is also beneficial that we interact with AI Group, and which will also allow a two-way flow of information from a horticultural perspective. The first webinar is designed as an overview of the changes and what they mean for our sector. We will be running a survey during the webinar to get feedback from growers on what areas you would like to see in the next webinar on the 9th of March. Please note that these webinars are being recorded and we'll put them online in the coming days. Further to the webinars, AI Group will be preparing additional notes to reflect the issues covered in today's session, and we will disseminate that information with the participants. AUSVEG's intention is to ensure that growers have access to up-to-date, accurate and practical industrial relations information that is directly relevant to our sector. I would like now to introduce Brooke West, who will be leading the webinar today. Brooke is a Senior Associate with AI Group Workplace Lawyers. Welcome, Brooke.
Thanks for that introduction, Lucy, and it's a pleasure to be presenting to everyone today in partnership with AUSVEG. And as we've touched upon, that will be on the most recent workplace relations legislative reforms. Covering off on the agenda of today's session, I will be particularly focusing on the various and most recent key changes introduced or to be introduced into the Fair Work Act, implemented by the Fair Work Legislation Amendment, Secure Jobs, Better Pay Act 2022. And those topics are broadly on your screen there for you now. And then I'll be ending today's webinar by briefly covering off on the next tranche of the remaining key legislative amendments, which are expected to be implemented by the government this year, some of which we expect will be highly relevant to the horticulture industry at large. There is a lot of content to get through today, so I won't waste any time and get straight into it. As Lucy suggested, and I will preface before I go into overwhelming you with a lot of information, all of this information will be disseminated into almost fact sheets for everyone on the call today. So if there's something that we go through and you are overwhelmed, please note that it will be put in a written form for you, so you will be able to revisit anything that we've covered today. So jumping in straight into the by way of background, the Fair Work Legislation Amendment Secure Jobs Better Pay Bill was tabled on the 27th of October in 2022. It passed both houses on the 2nd of December and it received royal assent on the 6th of December last year. So the Secure Jobs Better Pay Act, or the Amendment Act as I'll often refer to it as, introduces various and significant changes to the Fair Work Act today. And I'll be covering on a raft of topics or changes that have been introduced or will be introduced later this year, as certain changes commence operation at different points in time. So as I said, there are multiple components and changes having been made or are being made by the Amendment Act. And different parts will commence operation at different points in time. So the slide on your screen now sets out all of those various dates, and I will bring your attention to the far left-hand column. These are the changes that were operative from the 7th of December last year. And as you can see, several changes have already come into operation, including initiating bargaining, pay secrecy, job advertisements, and so forth. Apart from those, as you can see, a various number of other changes start later in the year. And as the slide indicates, in various instances, they'll either begin on a set date or a date to be proclaimed. Now, what that means is that the minister has an ability to proclaim an alternative and perhaps earlier date. There hasn't been any indication from the government that earlier dates will actually be selected by the minister, but just be aware it is a possibility. Employers should also be aware that some issues have been delayed by a period. So you'll see a lot of the changes in relation to bargaining in particular don't commence until the middle of the year. And that's to give you employers, growers, some time to prepare for those changes that might impact you. So that takes me to multi-employer bargaining. One of the things to be aware of is that the Fair Work Act already does contain a multi-employer bargaining stream. It is available as it stands, and it has been since the commencement of the Fair Work Act. But the multi-employer bargaining streams are what's said by unions in particular difficult to utilise, and there are too many technical barriers or hurdles. And as a result, there has been few attempts to engage with multi-employer bargaining on a larger scale. What the amendments will do at a high level is seek to remove many of those barriers. They'll make it much easier for parties and for unions in particular to engage in multi-employer bargaining. Now, within that context, there will be 3 streams of bargaining available under the Fair Work Act once these amendments fully come into effect, and I'll take you through some of the detail around each of those streams. But they include firstly the single interest employer stream, which as the name suggests, covers employers that have a common single interest, and that's the stream that will be applicable to many employers or growers at large. There is also a supported bargaining stream, which is replacing and somewhat expanding the current low-paid bargaining stream. And then there's the cooperative workplace agreement stream, which is an entirely voluntary stream. And so that will be another option that will be available to employers and growers. One thing to be aware of is that unions will have a much greater capacity to initiate multi-employer bargaining than they had before. They will be able to potentially commence multi-employer bargaining without an employer's consent, and I will talk through that later. There will also be a scope for employers to be added to existing multi-employer agreements that are made. So what that means is that there will be a potential scope for unions, for example, to seek and obtain an agreement with a small cohort of employers, and then subsequently make an application to have other employers added to that agreement, even though they did not directly negotiate it. So there is a real possibility that this will be used as a significant strategy by unions going ahead, but again, I will talk through that in a moment. And lastly, industrial action will also be permissible in support of either the supported bargaining agreement stream or the single interest employer bargaining stream. So this then takes us to the single interest employer stream. The way this process starts is that an application is made, and it can be made by employers or by a union to the Fair Work Commission for a single interest employer authorisation. Now, if the authorisation is granted, then an employer is required to engage in bargaining for a single interest employer agreement, meaning that they will not be permitted to separately try and strike their own agreement covering their specific workforce. Effectively, they'll be caught in this multi-employer stream. Once an employer or a grower is covered, it also means that you have to comply with the good faith bargaining requirements under the Fair Work Act, and you're covered by the rules around industrial action and the rules around handling of bargaining disputes and arbitration, which I will come to. So what does the Fair Work Commission have to be satisfied in order to grant an authorisation? Well, essentially there are 4 points identified and they're on the slide there. Firstly, for one of these authorisations to be granted, at least some of the employees that would be covered by the proposed agreement need to be represented by a union. So unions have to be involved. Secondly, employers and unions have to be given an opportunity to express their views to the Fair Work Commission about whether or not the authorisation should be granted. And once you've moved past those 2 tests, there are an additional 2 criteria that need to be met. First is that the employers have to be a common interest employer. And secondly, the operation and business activities of each of those employers that are to be covered have to be reasonably comparable. So what do those 2 tests actually require? So firstly, looking at the common interest test for employers. To be a common interest employer, the employer group have to have clearly identified common interest, and it must not be contrary to the public interest for the relevant authorisation to be made. What exactly is a common interest, or what in circumstances will an employer be found to have common interest is unclear, because there is actually no definition in the legislation, which is not very helpful. And ultimately it will be a matter for the Fair Work Commission to look at and determine. And some of the first cases around this issue will be really important to watch. However, there is some guidance in the actual Act and the explanatory memorandum to the Act. And so the legislation itself says that a common interest might include a consideration of factors such as geographic location. The explanatory memorandum suggests what that might mean is that employers in a particular regional town, for example, could be argued to have a common interest. So, for example, growers located in Orange in New South Wales, who are located 5 kilometres away from each other or within that radius, could be regarded as having a common interest. One of the other factors that might be relevant is a common regulatory regime. So many have suggested that that could include a common regulatory regime dealing with funding. So for example, employers under the NDIS, they might be argued to have a common interest as an example. And finally, another factor might be the nature of the enterprise to which the agreement will relate and the terms and conditions of employment. Again, the explanatory memorandum gives us some guidance and suggests that might include, for example, the size of the relevant employers. Moving beyond that, the Fair Work Commission will also have to look at whether the employer's operations and activities are reasonably comparable. Unfortunately, again, there is no definition of what reasonably comparable means. I would note that this is one of the amendments that was made last minute by the government in negotiations, or as a product of negotiations with the backbench. And this does actually add a level of uncertainty as to precisely who will be caught by this new stream. It is, however, arguably an improvement, and it does open the door to at least arguingly relevantly for this group, as an example, that employees at different levels of a supply chain don't actually have operations or activities that are reasonably comparable, and therefore they should not be caught by the same agreement. And that should be some comfort to growers, because some unions were arguing that supply chains should be covered by this multi-employer bargaining stream, which was concerning. The explanatory memorandum again suggests that the size, for example, of an employer group won't in of itself be a factor. So there might be employers who have different sized businesses, but nonetheless have comparable operations and activities. So they might again be caught. But we just have to wait for any proceedings brought by the Fair Work Commission dealing with these sorts of issues to really see how we're going to have to navigate this new stream. The legislation also sets out the different rules depending on the size of the employer. The short point is that if you're an employer who has 50 or more staff, it will be presumed that you have a common interest and that you're reasonably comparable to other employers covered by the agreement. And then you as the employer or the grower will have to prove otherwise. So you'll have to prove that your business isn't comparable to any other of the business operations, or that you don't have a common interest. And that's potentially a new burden for growers to discharge that obligation when matters come before the Fair Work Commission, something to be aware of. And the test, again, sorry, I've just changed that slide. The test is, however, different. If you've got 20 and 49 employees, there the onus will fall on the unions to have to prove that you do have a common interest and that you are reasonably comparable. Again, the applications for a single interest authorisation can be made by unions or employers. If they are made by a union, then each of the relevant employers to be covered either have to have consented to the application, or a majority of the relevant employees at the enterprise level, so that is each employer who will be covered by the agreement, need to have voted in support of it. So they have to want to be covered. In contrast, if an employer or a group of employers make an application, then they have to have genuinely agreed to bargain together, and they can't have been coerced by any persons. So they can't have been coerced by a union, for example, to participate. And not all employers are going to be covered by this stream, and there are some important exemptions. Firstly, small employers or growers. So that is an employer or a grower who employ less than 20 employees will be carved out, unless, of course, they consent. Employers are also carved out if they've got an in-term enterprise agreement. So that's an enterprise agreement that has not passed its nominal expiry date. And that really leads me to the point that the strongest protection from being drawn into this multi-employer bargaining stream is having an enterprise agreement in place. And we'll come back to whether that's an appropriate strategy. Employers are also carved out if you have a relevant agreement with a union to bargain for a new single enterprise agreement, and that agreement would cover substantially the same group of employees as would be covered by the authorisation. And finally, you'll be carved out if you've applied for yourself for a single interest employer authorisation, or you were already covered by one. In addition to those exemptions, there will be a general discretion also afforded to the Fair Work Commission to not cover an employer by a single interest authorisation in certain circumstances. And this is what is often being referred to as the grace period provision. So essentially, the Fair Work Commission can exercise its discretion not to cover an employer if they are bargaining in good faith for an enterprise agreement and they have a history of bargaining effectively. The explanatory memorandum suggests that bargaining effectively means at more than marginally above the award rate. So really what that means is that you have a history as an employer of bargaining that's delivered tangible and substantial benefits to employees. And finally, you need to have been bargaining for less than 9 months from the nominal expiry date for the agreement. And that's the grace period that I've just talked about. And that means employers or growers will have a window to bargain for a new agreement before you can be drawn into a single interest employer stream. But the big concern is that some unions may choose to wait that out and drag out negotiations. But nonetheless, it's a provision that's a benefit to employers and growers at large. So that brings me now to the supported bargaining stream. And this stream is intended to replace the low paid bargaining stream that currently exists in the Fair Work Act, but also expand on its coverage. If an application is made for a supported bargaining authorisation, the Fair Work Commission is going to have to make a decision as to whether it's satisfied that it's appropriate for employers to be covered by one of these proposed agreements against a range of criteria. The first being what the prevailing pay and conditions within the industry or sector are, and in particular, whether there are low rates of pay in that sector. The Fair Work Commission will also be required to look at whether there's a common interest. So again, similar to the single interest stream that I've just talked about. And it will need to consider whether or not the likely number of bargaining representatives for the agreement will be consistent with a manageable collectible bargaining process. So for example, a union proposed an agreement that covers industry, and that industry would be covered by a raft of representatives, then that would be a factor that weighs against the bargaining authorisation being granted. But again, at least some of the employees who will be covered by the agreement need to be represented by a union. And then there's a broader discretion of the Fair Work Commission to have regard to any other matter that it considers appropriate. Ultimately, there's also a broad power for the minister to declare that an authorisation should be declared in relation to a particular industry, occupational sector. And if the minister so declares, then the Fair Work Commission will effectively be required to grant such an authorisation. Employers who are again covered by an in-term enterprise agreement cannot be included in a supported bargaining authorisation, but there is an anti-avoidance provision that you need to be aware of. The Fair Work Commission will have the power to rope an employer in if it forms the view that employers have just entered into the EA just to avoid this stream effectively. And once a supported bargaining agreement comes into effect and covers a particular employer, then it will effectively knock out any individual enterprise agreement that would otherwise be applicable, and that agreement can never apply to them again. And once again, one of these supported bargaining agreements, they're in place. A union can make an application to the Fair Work Commission to add employees to that stream, and it will be really difficult for employees to remove themselves from such an agreement or authorisation. And then that takes me finally to the cooperative workplace bargaining stream. And this is a stream which is essentially voluntary. It's a stream that enables a group of employers to bargain together. And it is envisaged by the government that this might be attractive to small employers or growers who wouldn't ordinarily have the resources to individually bargain for an enterprise agreement, but who may like to pool their resources together to bargain for an agreement that sets common terms and conditions. Essentially, employers can opt into this stream or they can opt out. So it doesn't operate by way of an authorisation ordered by the Fair Work Commission, as I've just discussed. It is a voluntary process entirely. But still, to engage with this stream, at least some of the employees proposed to be covered by any agreement must be represented by a union. And one of the important differences between this stream and the other streams is that protected industrial action cannot be taken in support of a cooperative workplace agreement. So this just brings me to some general observations around multi-employer bargaining. The first is that there's not going to be an obligation to issue something called a Notice of Employee Representational Rights, or what we in IR land refer to as a NER. And that's for the multi-employer agreements. So the NER is a notification essentially that informs employees of their rights to be represented by a bargaining representative during the agreement making process. And that is required to be issued no more than 14 days after the bargaining process starts. So that's no longer going to be a requirement. Secondly, and this is quite a significant change, if an employer wants to put a proposed multi-employer agreement to a vote to its workforce, so effectively make the agreement, it will need to obtain the written approval from each union representative engaged in the bargaining. So effectively, unions will exercise a high degree of control over when those agreements can be made and what their terms will be. Now, there is a provision that allows you, a grower employer, to go to the Fair Work Commission if you're finding yourself in a situation where you regard that the union has unreasonably withheld that permission, and you can get an order that enables you to put that agreement to vote. But that is a big change from the current arrangements, and it's another step that employers and growers are going to have to take if they're engaging in agreement making. And in each of these three streams, provisions will be available to enable employers and employees to be added and removed to each types of the agreements once made, and the rules will vary based on those different streams. So then this leads to some general issues for consideration. And the first is that what are the possible union strategies going to be in relation to these new forms of agreement making? The thing that I would like to make you all aware is that obviously this form of bargaining, it was actually a product of ACTU calls for changes to the Fair Work Act. But what we've seen is a lot of unions calling out in support of those changes. Originally, it was argued that these forms of bargaining were really important in certain sectors where there was little bargaining occurring historically. So the low paid sectors such as the disability sector, aged care, and certain sectors like security, for example. But realistically, what we're now seeing is a broad range of unions across all industries and sectors coming out in support of these changes. So growers and as employers, you should be aware that it is likely that unions will strike to utilise multi-employer agreements as a part of their strategies. If you've had previous union activity on your farms, just be aware that they might move to strike and get more heavily involved, potentially coming on site, talking to employees, etc. The other risk, as I alluded to at the start, is the possibility that unions might seek to strike agreement with small cohorts of employers and employers who are particularly friendly to union claims, and then pursue a strategy of seeking to rope in other employers or growers to extend the coverage of that agreement to others who weren't directly involved in that negotiation. And so that brings me to the point now that it really is an opportune time to think about if you don't want to be embroiled in this new system, or if you think that there's a potential that you might be, what you should do, and the clearest strategy available, is really to think about implementing an enterprise agreement or renegotiating your agreement if you have one in place. And whether or not that's worthwhile will depend on your specific circumstances, but now is really a good time to start thinking about it and getting some strategic advice around that from either in-house if you have those resources, or from an IR specialist who can assist you with determining whether it's an enterprise agreement is something that you should be considering. This now takes me to the changes in relation to single enterprise bargaining agreements. One of the big changes relates to how bargaining is initiated. In essence, the changes to the Fair Work Act enable unions to initiate bargaining simply by giving a written request to an employer, saying that they want to bargain in the context of an agreement that's past its nominal expiry date, provided that that agreement hasn't passed its expiry date by more than 5 years. So if you're outside the term and that term passed is less than 5 years ago, the union just needs to write to an employer to start bargaining, provided that the agreement they're seeking covers the same or substantially the same group of employees as the early agreement. So what that means is you as an employer or a grower, if you have an enterprise agreement, you will no longer have to agree to engage in bargaining, and it removes the need for unions to seek a majority support determination, which they currently did. And this change has already come into effect. It came into effect in operation on the 7th of December last year, so it was an immediate change. So if your organisation has an in-term enterprise agreement, and you have a history of making enterprise agreements, again, if you don't have an EA, this is not as applicable to you, but you really should start thinking about needing to engage in, with a union in preparation in the final weeks, just given the ease in which bargaining for a replacement can be triggered. There's also been some changes around industrial action. And I might say at the very start that most of the rules around industrial action have remained undisturbed, but there is a new requirement for bargaining representatives, so unions, or employer representatives to attend a compulsory conference before the Fair Work Commission during what's called the protected action ballot period. So if a union makes an application seeking a protected action ballot order, during that period in which the vote is being arranged, the parties will effectively have to come before the Fair Work Commission and participate in conciliation before any industrial action can be authorised. So this is an improvement. There has also been an expansion of employees' rights to take industrial action in support of multi-employer agreements, as I've talked about. In particular, at the moment, unions can't take industrial action in support of low-paid bargaining agreements, but it will be available now in the context of the low-paid bargaining stream. And one of the amendments that was made to the Act was that it will be a requirement of the relevant majority of workers in each workplace. They'll need to agree for that industrial action for that to happen. And then finally, in the context of the multi-employer bargaining, there is going to be an obligation for 120 hours or 5 days notice of any proposed industrial action to be given. So many big changes. There's also been some big changes to the agreement approval process, or the processes for making agreements, essentially. Growers may or may not be aware that there are highly prescriptive rules around how an agreement is made and approved. For example, how you organise a vote, what information you give to your employees and when, and so forth. These current rules are to a large extent going to be overridden by an overarching general requirement that the Fair Work Commission just has to be satisfied that an enterprise agreement has been genuinely agreed. So the Fair Work Commission won't be looking at whether specific steps have been followed, just whether they can be satisfied that there was a genuine agreement by the workforce. To accompany this, there will be a requirement on the Fair Work Commission to publish a statement of principles, setting out guidance about what is required in order to ensure genuine agreement. And that will deal with things such as the information that is to be provided to employees about their rights to be represented, opportunities given to employees to consider and understand that agreement, and ensuring that a vote is conducted in a free and informed manner. The point is that this statement of principles won't have to be strictly applied, but they will provide a roadmap in which the Fair Work Commission will be required to consider when approving an agreement. And we expect that the Fair Work Commission will shortly convene proceedings to give consideration to what those principles should look like. There is still a requirement to hand out a notice of employee representational rights, or again, the NER, but that's in the context of the single enterprise agreement. So they've been removed in the multi-employer, but they remain in the single enterprise agreements. But nonetheless, the Fair Work Commission is still given a broader power to disregard minor procedural or technical issues in the making of agreements, and that includes disregarding deficiencies in relation to that notice. So there are some slight changes there. There will also be a new and substantial additional requirement on the Fair Work Commission approving agreements, and that relates to a requirement to ensure that it's sufficiently representative. Now, what that means is that the Fair Work Commission will have to be satisfied that the cohort of employees covered by or who voted on the agreement are sufficiently representative of the cohort to be covered. And so, for example, you won't be able to have an agreement struck with a small number of employees or a limited number of classifications if the agreement itself is going to cover a much larger group of workers and a much broader range of classifications. And that will be a big issue for some sectors. There has also been a raft of changes in relation to the Better Off Overall test, or what we refer to as the BOOT. There are some improvements, but there's also some sting in the tail, so to speak, with respect to some of these changes. One change will be which employees have to be better off overall under the agreement, and the test will be changed so that it will no longer be each prospective employee that must be better off, and that is going to be replaced by a requirement that each reasonably foreseeable employee must be better off. There is also going to be a new requirement that the Fair Work Commission give consideration to the views of employees and employers, as well as bargaining representatives, in the application of the BOOT. So that's really going to be beneficial, as it should help ensure practical outcomes. But importantly, the Fair Work Commission will be required to give primary consideration to any common views expressed by bargaining representatives of either the union or the employer. So if you have an employer representative and the union agreeing, then the Fair Work Commission is really required to give it primary consideration, and that really should ensure that all matters that parties mutually regard as being beneficial don't get caught up and held up in the Fair Work Commission, which we have seen in the past. The Act will also clarify that the BOOT is to be applied as a global assessment, so overall. So it's not a line-by-line comparison between the proposed agreement and the relevant modern award. At the moment, it's line-by-line, and that can be a very tedious process and a long process. So that's a beneficial change. And the Fair Work Commission is only going to be able to have regard to reasonably foreseeable patterns or kinds of work and the types of employment at the test time. So the test time is when it passed or was, assessed against the award at the time. So what that means is that the Fair Work Commission won't be able to have regard to hypothetical scenarios, which it has been able to have in the past. As an example, if you have an employer or a grower, for example, who only operates from Monday to Friday, and it's not reasonably foreseeable that they will have operations on a Saturday, then the Fair Work Commission shouldn't and won't have regard to the impact of an agreement, for example, that doesn't have penalties on a Saturday. And that's simply because those patterns of work are not likely to be performed. So they're all really, really beneficial, but there is, as I said, a bit of a sting in the tail with some of these changes. And the first is that the Fair Work Commission forms a view or concern that the agreement does not pass the BOOT. It's going to be empowered to simply amend the agreement to address that concern by changing the agreement's terms, a term, or just excising some of the terms from the agreement. The Fair Work Commission is required to seek the views of employers before it does that, but ultimately, it will be able to rewrite an agreement in any way that it sees fit to ensure that it meets the terms of the Better Off Overall test. Although it's only empowered to make changes limited to that are necessary to meet those concerns, so it can't just go in and make any change to your agreement that's proposed. This is a risk for growers who are considering an enterprise agreement going forward, and it's a big change from the way that the Act operates now. The other big change to the BOOT is in relation to the introduction of an entirely, an entirely new reconsideration process. So currently under the Act, employers, unions and employees, they will have an ability in specific circumstances to apply to have the BOOT reassessed. And that's a change because at the moment, once you've passed the BOOT and the agreement is in play, it's come into effect, that's the last time that it's considered. There's actually no scope to have that agreement retested. However, this ability for an employee to make an application for a reassessment is only going to be triggered if there's a change or the employee works in a different pattern of work or a different type of employment. And by that, I mean, for example, works in a casual employment when that wasn't considered. So it's only really if there's been a change to what was actually considered by the Fair Work Commission when it was proved. So there is some limitation there. And that is that's also the test time. So if a party makes an application for the reconsideration, the Fair Work Commission will consider the agreement versus the award in terms of the boot assessment, but at the time that it was first approved by the Fair Work Commission. So it won't be at the time now, the present time of the application. So if the Fair Work Commission identifies a concern that the agreement does not pass the boot on reassessment, again, it can change the agreement and it can effectively amend the terms and conditions, or it can accept an undertaking from you as the employer to address those concerns. What is particularly noteworthy is that the Fair Work Commission, if they do form the view that it needs to make a retrospective change in order to address the concern, it must do that. So now what that means is that there's a very real risk that the Fair Work Commission can change an agreement to create a retrospective underpayment, and an employer may need to provide an undertaking to undertake reconciliations and back payments if required. So it means a lot more attention is going to be made in terms of the framing up of agreements and really needing to consider their impact in the context of your potential changes to your operations as a grower or an employer. And these changes to the boot are operative from the 6th of June this year, so there is some time before they come into effect. Another major area where there's been some changes is in relation to bargaining, and that's in respect of the handling of disputes. That big change is that the Fair Work Commission is going to be empowered to arbitrate bargaining disputes, so to effectively determine the outcome of bargaining and to oppose terms and conditions on employers and employees. And there is a process that will enable this to occur. And the first step in that process is a party applies to the Fair Work Commission for what is known as an intractable bargaining declaration. And that can be granted if 3 criteria are met. And the first is that the parties have to have engaged in dispute procedures or proceedings before the Fair Work Commission. Secondly, there has to be no reasonable prospect of an agreement being reached. And then thirdly, the Fair Work Commission has to be satisfied that it's reasonable in all the circumstances to make that declaration. And that includes taking into account the views of bargaining representatives for the agreement. Once that threshold has been met, the Fair Work Commission can then issue a bargaining declaration. They can give the parties a further window if they think appropriate to try and reach a further agreement. And we call that something called a post-declaration period. But if no agreement is ultimately reached between the parties in that period, it then proceeds to arbitrate. So effectively, the Fair Work Commission decides the matter in dispute and sets the terms and conditions of the agreement. So the agreement won't reflect the terms that you've agreed, but rather the outcomes that the Fair Work Commission deems appropriate. Now, there is a safeguard that will apply, and that is that the Fair Work Commission cannot issue one of these declarations unless more than 9 months have passed since the expiry of your old enterprise agreement or since you began bargaining for a new one. It's the later of either of those dates. So there is a 9-month of bargaining that will have to apply in all circumstances. This change, again, comes into operation from the 6th of June. So employers will need to carefully consider their bargaining strategy in light of expanded avenues for the Fair Work Commission to apply pressure on industrial parties to make concessions in order to reach an agreement. So if you are considering an enterprise agreement, you may well need to consider or identify at the outset any kind of bargaining issues that are most likely to be unresolved, and really think about your arguments and your considerations of how you will convince the Fair Work Commission not to impose the unwanted outcome by arbitration. One of the other big changes in relation to bargaining is in relation to the termination of enterprise agreements. There is an ability under the Act at the moment for an employer to do so, but it has rarely been used. But that scope for an employer to make such an application is going to be further curtailed. And there are essentially a few grounds that will be available in which the Fair Work Commission will grant a termination. The first is where the continued operation would be unfair for the employees covered by the agreement. And I note that there is no corresponding right for an employer to make an application if the continued operation is unfair to them. The second will be a situation where the enterprise agreement does not and is not likely to cover the employees. And then thirdly, and this really goes to the right of the employer's right to terminate, and that is where the continued operation of the agreement would pose a significant threat to the viability of the business, or whether the termination of the agreement is likely to reduce the potential for redundancies, bankruptcy, or insolvency of an employer. In considering any application to terminate an agreement, the Fair Work Commission must consider whether the termination would adversely affect the bargaining position of the employee. So what the Fair Work Commission will look at there is really having a look at whether it's just a part of a strategy to strengthen an employer's bargaining position by getting rid of a previous enterprise agreement. And the final point is that you can still make an application to terminate agreements. That has not changed, but you need to have consent of the relevant majority of your employees. The final issue I want to talk through in relation to enterprise bargaining is the sunsetting of zombie agreements. Zombie agreements are, in simple terms, those agreements that have been in place prior to the Fair Work Act, or 2010, and agreements that were never assessed relative to a modern award. So that's what happens now when you're going through the enterprise agreement process, or the boot. So any such agreements under the Act will sunset from 12 months from the day of royal assent. So that was the 6th of December 2022 last year, so 12 months from then. And an employer will have to give the affected employees at least 6 months notice that that's going to happen. There is an ability to make an application to the Fair Work Commission to extend this period if necessary, up to an outer period of 4 years. So there is an extension ability there if you need it. And the transition is important with respect to the zombie agreement. So growers and employers, you'll need to identify whether you're actually covered by a zombie agreement and determine whether you should be or whether you need to be applying for an extension, and then think about the various arrangements that you need to do as a flow-on effect. And that is either negotiate a new agreement or transition to a different industrial agreement, including potentially a raft of other changes to your payroll processes and so forth. Because at the end of a sunset period, your employees' paying conditions will automatically be set by the relevant modern award, or alternatively a new enterprise agreement if you've arranged one. So the important point is that these provisions have already started. So the clock has already started ticking, and you should take action now really to develop an appropriate strategy if you are on a zombie agreement. And I would recommend that you have a look at whether you've got one that applies to your operation at the moment. So the remainder of the changes to the Act largely really focus on compliance in a range of matters. The first of which is flexible work in the National Employment Standards, or the NES. The right to request flexible work is a right that employees have currently under the Fair Work Act at the moment, and many of you may or may not be familiar with that already. The Amendment Act does make some fairly significant changes to the operations of those provisions. And the first is a rather minor amendment, but it's an important one, and that's concerning the eligibility of employees to make a request for a change. And that's expanded to an employee if they or a member of their immediate family or household experiences family or domestic violence and an employee is pregnant. And secondly, a change that will affect, it affects the procedural obligations on employers in addressing requests for flexible work. And these obligations concern discussing the request with the employee, but also genuinely trying to reach an agreement prior to refusing an employee's request, providing written detailed reasons for that refusal within 21 days, and as well as informing the employee of any alternative working arrangements that you as an employer would be willing to make instead to accommodate that employee's circumstances. In addition to that, the Fair Work Commission will also have an expanded or greater role, and they will be empowered to deal with disputes in circumstances where if you as an employer refuse an employee's request or you don't respond within that 21-day time frame. The Fair Work Commission will be required to deal with a dispute through dispute resolution measures, that is either through conciliation or mediation, and they only deal with the matter through arbitration in exceptional circumstances. The Fair Work Commission may make an order that you as an employer take further steps as considered appropriate or if it's not satisfied that there are reasonable prospects of the dispute, the Fair Work Commission may in fact order that the employer, you as the employer, grant the request. And that's with or without changes to the actual flexible working arrangements requested. In addition, it's also important to note that there is also going to be an imposition of a new civil penalty provision, and that's for an alleged contravention of this amended NES. And this includes where an employer refuses a request in the absence of reasonable business grounds, or where there has been a contravention of a Fair Work Commission order, which I've just discussed above. You know, for businesses or growers, if you have a policy on flexible work arrangements or working arrangements generally, I would encourage businesses to look at that and just be aware that there may be a change to the eligibility of employees to make those requests and the processes that you need to follow procedurally. So if you've got steps perhaps in your policies, you might need to revisit those and just amend them. Similar to the changes to the right to request flexible working provisions concern the new obligation on employers to request an extension to unpaid parental leave, which is currently a right under the Fair Work Act at the moment, and that can be an extension request for up to 12 months. Again, the new procedural obligations are almost the same. They mirror the obligations applying to addressing the request for flexible working arrangements. And like flexible working arrangements, again, the Fair Work Commission will have the power to conciliate and arbitrate disputes relating to these requests, including, again, for the ability for the Fair Work Commission to make orders, effectively ordering that the employer grant the request. Like flexible work, there will also be the imposition of several civil penalties for employers who are found to have contravened these provisions, or if there is, again, a contravention of the Fair Work order. So these amendments, along with the flexible working arrangement amendments, will take effect on the 6th of June. So there is a period of time for growers to evaluate their arrangements and have regard to these new changes. The next change relates to pay secrecy, and a recent change we see as a means to, promote gender-based equality, which is a big theme in terms of the government's labour commitments. It doesn't just concern what employers have in a contract, but the Act creates effectively a new workplace right for an employee or employees to disclose or not disclose their remuneration, but to also ask other employees about their remuneration. So importantly, the definition of remuneration extends not just to the rates of pay, but also the terms and conditions that will be reasonably necessary to determine remuneration. So that's really important because it could include an hourly rate of pay, but also the number of hours that the employee works and any bonuses or commissions. These workplace rights expand basically the current general protections provisions. So what that means is that an employer, so you as an employer, can't be taking adverse action because an employee has exercised its workplace right to disclose or not disclose their pay. In addition to the creation of that new workplace right, contracts of employment or other written agreements that contain provisions or clauses that are inconsistent with these new rights, such as, the pay confidentiality clauses, they'll effectively have no effect. And moreover, any contract or new contract that has any such term may attract a civil penalty. So it's really important that you're made aware that any new contracts of employment that you might have that might contain, I'm not sure how common it is in this industry, but just something to be made aware of. And these changes have commenced already. So they are in effect. There are some transitional provisions in terms of the existing contracts as well as the provisions relating to new contracts. But as employers, you are all encouraged to seek advice and just having a look at any such terms in your contracts. And as a matter of compliance, it will be necessary again to remove any terms in your standard employment contracts which require pay confidentiality. Another area of change relates to the restriction of the limitation on the use of fixed term contracts. Effectively, this restriction will be a prohibition on employers from entering into a fixed term contract with an employee for an identifiable period greater than 2 years, or in the case of renewable contracts, where the contract can be renewed or extended so that the employee is employed for more than 2 years, or the contract provides for an option or the right to extend or renew the contract more than once. That is a mouthful, and it is quite complex to get your head around. The written material will provide assistance in this space. It is important to note that there are some fairly broad anti-avoidance provisions around these limitations as well. And this means for employees who, for example, might seek to terminate and then re-engage employees on fixed term contracts as a way of bypassing the prohibition, for example, they would be in breach of these anti-avoidance provisions, and they attract a civil penalty as well. There are some important exemptions, which I will go through in the next slide, but they will be available to allow fixed term contracts beyond these limits when genuinely necessary and appropriate. But as a starting point, this is not applicable to casual employees. So if you have a large casual employee workforce and you utilise fixed term contracts, there is an exemption for such employees, and no such limitation will apply. Employers who enter into fixed term contracts also need to provide a fixed term contract information statement to employees, and that is whether they are exempt or not. And this is similar to the Fair Work information statement, which you should all be providing new employees when you engage them. And that again is published and made available by the Fair Work Ombudsman, but it will be your obligation as an employer to provide that to the relevant employee. Again, a failure to do so gives rise to a civil penalty. There's lots of new civil penalties in these Amendment Acts, if you haven't noticed. And if an employer enters into a fixed term contract that's prohibited, not only could that attract a civil penalty, but it's really important. This is a big change. The employee would actually be deemed to be a permanent employee, such that the contract would continue. It would be enforceable, except for the expiry date. And you as an employer, you couldn't rely on that expiration date to terminate the employment. So effectively, this in most instances will give rise to entitlements of an employee, such as the notice of termination or redundancy pay. And most relevantly, they may have, in some instances, access to the unfair dismissal. So something to be aware of. Again, the Fair Work Commission has an expanded role. They will be able to have the jurisdiction to resolve disputes about these provisions. And employees who wish to pursue these complaints, they also have an avenue to go to the Federal Small Claims Jurisdiction, which is a jurisdiction I'll talk about in a moment. As I said, there are some important exemptions which will be available to allow fixed term contracts. And a range of these exemptions will allow contracts beyond those limitations. I won't go through them in each detail and itemize each, but I will draw your attention to contract of performance of work to undertake essential work during a peak demand. So for some example, growers may be able to rely on fixed term contracts for peak seasonal periods, which is common in the industry. But what we really do is encourage employers to become familiar with these exceptions to the limitations. Consider if they apply to your business or your operations or specific employees that you may have. And that's particularly important if you intend to rely on an exemption, because the onus will be on you as the employer to demonstrate that the exemption actually applies. So the operative date for this change is the 6th of December this year. So there has been a bit of a bridging period of 12 months to ensure that growers and employers, if you are utilising fixed term contracts, you're able to comply with these new restrictions. It's also worth noting the new provisions might apply to labour hire assignments and the employers of labour hire staff. So if you utilise labour hire, which I understand is common in the industry, you growers and employers may also need to consider how these provisions apply in the context of their labour provided and relied upon, and engage in appropriate management discussions with labour hire providers. Though I do acknowledge that the transient and seasonal nature of your employment relationships is casualised and often won't extend to the 2-year period, but it is something to just be mindful of. Quite a different topic, sexual harassment at work. The Amendment Act introduces some changes in relation to how employees should prevent sexual harassment. This is in addition to, you might have heard the Respect at Work, the Respect at Work Act, but there was an additional layer, or the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Bill, that came into effect on the 13th of December. And that, amongst other things, inserted a new positive duty to eliminate sexual harassment into the Sex Discrimination Act. Because of time, we won't have, I can't go into the details of the Respect at Work, but this is an additional amendment that introduces new provisions. And we will provide you all of an opportunity, if you would like, as a topic, we can go through the sex discrimination and the Respect at Work changes in more detail in another webinar. Effectively, the Fair Work Act now has a prohibition as well on sexual harassment. And the effect of that prohibition is that it attracts a civil penalty, and that's currently set at $66,000 per contravention. The sexual harassment prohibition is in connection with work and applies broadly to workers, prospective workers, and also persons conducting businesses or undertakings. And that's aligned with work health and safety terms. So there is a broader coverage beyond just the employee and the employer relationship. Importantly, growers, employers, you should be made aware that you can now be vicariously liable for the acts of your employees or agents if you cannot prove that you took all reasonable steps to prevent the prohibited conduct or the sexual harassment. In addition, the Fair Work Commission again will have a new dispute resolution jurisdiction, and that will be extended to not only enable it to continue to make stop sexual harassment orders, that's currently within its jurisdiction, but it can also deal with a dispute in some other manner by conciliation or mediation if it concerns sexual harassment. They can't, the Fair Work Commission won't be able to order a pecuniary amount at that stage, so the conciliation or the mediation. They can make orders, for example, to require a person or persons to stop the behaviour or compliance or the development of a sexual harassment policy, etc. If, however, the dispute remains unsettled and it does go to arbitration, the Fair Work Commission can actually make orders including the payment of compensation. So that's something that employees should be made aware of. And an applicant may also proceed to the federal courts in the same manner as they do with a general protections matter. These provisions commence again on the 6th of March, so there is some time. But because the legal landscape with respect to sexual harassment has changed significantly, employers and growers, you need to be made aware that your current practices, they might not be sufficient to comply with the new legislative requirements, and that is discharging, the obligation that you took all reasonable steps to prevent the prohibited conduct or sexual harassment. So you should make sure that your relevant policies and practices regarding sexual harassment are reviewed, they're up to date, and that your workers understand what sexual harassment is and the organisation's expectations, or you as an employer, in relation to such matters. And that may require additional training or an update to the training that you currently have in place. And this again will depend on the environment in which you're operating. For example, if you're providing live-in accommodation to your employees, as is often in the case in the industry, your requirements to discharge that onus will be very different to someone who doesn't have those environments for their employees. In addition to that, there are 3 new protected attributes to the protection of discrimination introduced into the Fair Work Act. These include breastfeeding, gender identity, and intersex status. These attributes will be protected from discrimination for the purposes of general protections, but will also inform how the Fair Work Commission exercises its functions and powers, so not to discriminate on those grounds. There are also amendments now that enable an enterprise agreement to contain special measures to achieve equality, such as positive discrimination measures, perhaps in respect of women or First Nations groups to address historic disadvantage. As an example. So those provisions commenced on the 7th of December and they are currently in effect. Briefly moving on to small claims. Some of you may or may not be aware, but if an employee has an underpayment claim, they currently have the opportunity to make an application in the small claims jurisdiction within the Fair Work Division of the Federal Circuit and Family Court, or a magistrate's court, and they can seek orders for compensation in relation to entitlements that have not been paid by an employer. And that currently is a jurisdictional limit of $20,000. However, from the 1st of July this year, the maximum monetary threshold on amounts that can be awarded or sought by an employee will increase from $20,000 to $100,000. So this is quite a significant increase on the maximum amount of a claim that an employee may bring. Importantly for employers or growers, if you find yourself in an unfortunate situation where you are in small claims, you should be made aware that small claims processes are deliberately informal, and in most cases, lawyers are not permitted as a right to appear on your behalf. And claims made by employees are not tested to the same rigor in courts because the small claims process is not bound to follow the ordinary rules of evidence. So it's a bit more loose. But the important thing is that the court in this jurisdiction is not empowered to award penalties for an alleged underpayment, and that has remained unchanged. There are some changes which are now in effect, which prohibit employers from advertising or causing to be advertised. So that is engaging another company, to do so. Advertise a job with a pay rate that would breach the Fair Work Act or any other rate in a Fair Work instrument, such as a modern award. Most relevantly to this group, there are now particular requirements for advertisements that include piece rates, such that the piece rate must be specified, but also an hourly rate or weekly rate of pay to which your piece worker or the piece worker advertising would be entitled. So, for example, the applicable minimal hourly rate in the horticulture industry award. These changes are now in effect, and they are civil penalty provisions. And the Fair Work Act now empowers the Fair Work Ombudsman and also unions to commence legal proceedings for a contravention of this provision. So it's really vital that you make sure that your job advertisements are advertising a correct rate of pay. You won't contravene this provision, however, if you have a reasonable excuse for non-compliance. The term reasonable excuse is not defined, but what is reasonable will depend on the circumstances in consideration of the actual provision. So, for an example, if you as an employer, you would have a reasonable excuse if you exercised your due diligence to ensure that the advertised compliance rates of pay were compliant, but you received incorrect advice and the applicable rate was given and reasonably relied on in that advice. So that's just an example of when you may or may not have a reasonable excuse. Importantly, Fair Work inspectors from the FWO are also able now to issue compliance notices if they form a reasonable belief that an employer has contravened the provision. They have an ability to issue these compliance notices now for when they have a reasonable belief for underpayments or certain breaches of awards, for example. But that's been expanded now to include a reasonable belief for a contravention of an incorrect ad, and you may be required to take specified action, and that could include just taking down the advertisement or revising the advertisement. It is important to note that a failure to comply with a compliance notice is also a civil penalty provision, and so the FWO can commence legal proceedings for a failure to comply. So if you get one of these compliance notices, take action and comply or seek some advice, but you need to be aware that it can result in another penalty. So if you receive one of these compliance notices, take it seriously. And finally, the changes involve, in addition to the job security and gender equality, to existing objectives of the Fair Work Act and the modern award objectives. So the gender equality will be inserted into the minimum wages objective, and this will mean that Fair Work Commission, in deciding matters before it or conducting its own proceedings at its own motion, they'll need to now consider the objectives of job security and gender equality in setting terms and conditions at the award level or interpreting particular provisions of the Fair Work Act. In addition, there will be changes to the work value provisions such that the Fair Work Commission is required to consider whether work has been historically undervalued because of gender-based assumptions, and there will be a prohibition on such assumptions being made. This really concerns applications like the equal remuneration provisions that we have seen a number of unions and other applicants apply for increases to minimum wage rates of pay in the disability and care sector. And in terms of who will be undertaking those functions, the creation of 2 expert panels will be curated within the Fair Work Commission, who will be undertaking the role for determining work value cases and equal remuneration in many circumstances. So that concludes the list, if you like, of the matters of the changes to the Fair Work Act. I understand that you're probably extremely overwhelmed with the amount of information that I've just downloaded upon you. But we will end with something a little bit more light touch, and that is just going over, the Amendment Act really effectively was the government's immediate actions in relation to their labour commitment objectives. And so in the lead up to the 2022 federal election, the Labor government did announce, a lengthy list of workplace relation changes that it intends to introduce as a matter of priority. And so whilst major aspects of its agenda have already been implemented by the changes that I've just gone through, the following matters remain outstanding and are expected to potentially be addressed this half of the year. And in a second tranche of changes and reform, some of which are relevant to the industry. These include amending the definition of a casual employee in Section 15A of the Fair Work Act in a manner, so an employer's capacity to engage employees in an ongoing regular casual employment. So that may intersect with the current casual conversion that we have currently in the Fair Work Act. With reference to labour hire arrangements, ensuring that employees who do the same job receive the same rate of pay, extending the powers of the Fair Work Commission to include employee-like forms of work, and to enable the Fair Work Commission to set minimum standards for contracting. So that's, the platform gig workers such as Uber, for example. They're also looking at implementing the criminal offence for wage theft, including a right to superannuation within the National Employment Standards, or the NES, so that an employee has an ability to pursue their unpaid superannuation as a workplace entitlement. They currently don't have the ability to do that, so that's something that they're looking at changing. And lastly, considering the development of new portable long service leave schemes that will allow workers to move on from project to project or from job to job within a single industry to accumulate long service leave. So they're the expected things to come on this side of the year. We're not precisely sure what that looks like, but we are expecting that the government will start consulting on these new changes. So that wraps up today's webinar. I'm not sure whether we have time for any questions. But we did mention that this is the first of 4 webinars that we'll be holding for AUSVEG growers. And we would like to put some prospective topics for the next session. And we would like to ask your views on which of the 3 topics would be of most value to you, and which we would like to cover in the next webinar, which will be held in March. That's all from me, Lucy. If you've got any comments that you would like to add.
Lovely. Thank you very much, Brooke. And I know there was a lot of information in there for everyone. We don't have time for any questions, but I think Brooke's going to put a slide up next, which has my contact details on there. So if you have any questions, please feel free to email those through to me. And if it's not covered in the notes that we will be sending out, then we will get back to you on those specific questions. So we look forward to those poll results. The next webinar is scheduled for the 9th of March. And we will send invitations out for that and the topic being covered once that is finalised. So thank you very much, Brooke. Thank you for everyone who's attended, and we'll see you again in a month or so.